You're in love, everything is going perfectly. You've been talking about marriage, and you're about to buy a house. And your significant other asks you to add their name to title. And you think, hey, why not? We're going to get married soon. We're going to be together forever. Yeah, I'll do that. What could possibly go wrong? Well, I'm about to tell you what could go wrong. My name is Sharon Smoot. I'm an attorney and a realtor in the metro Atlanta area. And today I want to talk to you about why adding someone to the title to your home, particularly a non spouse, is so risky. A few years ago, I did a video about the dangers or warning people really not to add someone to the title to their home. And today, I just want to delve more deeply into why doing so can be very risky to you. The scenario that I laid out for you is based on a true story. Years ago, I handled a closing for a young lady. She was a first-time home buyer, and her boyfriend attended the closing with her. And during the closing, I noticed that he kept whispering in her ear, he kept nudging her. And at one point, I remember thinking, what is up with him? That is just so weird for him to be doing that. In the middle of this closing, she's trying to pay attention to the documents that I'm explaining to her. And he's just steady, and it was just weird. And finally, she says, oh, yeah, I want to add him to title. How do I do that? And in my mind, I am just screaming, like, please don't do it. I'm trying to send her telepathic messages. Don't do it. But she did it. Fast forward a few years, she contacts me and she says, I don't know if you remember me, but you did my closing when I bought my house and I added my boyfriend to title. The relationship is now over. He's refusing to move out. He's refusing to quit claim his interest in my home back to me. What do I do? How do I get rid of him? How does she get rid of him? There's not a whole lot that she can do short of litigation. There is an action called a quiet title action. And that is typically how these types of ownership disputes over property are handled. And quiet title actions are fairly complex and they are time consuming. And I would never recommend that a lay person undertake this type of legal process on their own. You need to be represented by an attorney. I explained all that to her, and she's like, well, I don't have any money to pay an attorney. Is there anything else that I can do? What if I move out? And I'm like, yeah, sure, you can move out, but you're still legally responsible for paying the mortgage. So if he stops paying and the home gets foreclosed on, nothing's going to happen to him short of maybe his stuff getting put out on the street if he doesn't move out after the home is sold at a foreclosure sale, but your credit will take a hit. And she was just stunned that she was stuck in this situation with this person that she didn't want to be with, a person that she no longer cared for, and that she was basically being held hostage. There was no way for her to get him out of her house without going to court and suing him. And I don't know how it was resolved, because when I quoted her my fee for doing a quiet title action, she was like, yeah, I don't have that kind of money. So that brings us to risk number one. When you add someone to the title to your home and they are not your spouse, they're just a significant other, you can end up in the exact same situation as this young lady did. So that's risk number one. Let's move on to risk number two. You add the person to title. Unbeknownst to you, they have a lien or a judgment of some sort against them. Guess what happens? That lien or judgment attaches to your home. So when you want to refinance, you're not going to be able to do it unless that person's creditor, whether it is the IRS, it is the Department of Revenue, it is a credit card company, it is the plaintiff in a tort case, maybe a personal injury case against the person, anyone who has a lien or judgment against that person that you added to title and you're ready to refinance will need to be paid off. Now, they might agree to release the lien without receiving payment, but that's something that you would have to negotiate with them. And 9 times out of 10, they're going to want at least a partial payment. And they will do a partial release where they're essentially releasing their lien on your home so that you can move forward with your refinance or the sale of the property. But my point is this: whenever someone has a lien or judgment against them, it attaches to all real and personal property that they own or that they acquire in the future. So, your boyfriend has a federal tax lien. You don't know anything about it because you're not all in his finances, but you think it's a good idea to add him to title because y'all are in love. That federal tax lien attaches to your home. And until it's paid off, it will remain a lien against your property. And that hamstrings you from being able to refinance, from being able to sell. And like I said, you may be able to negotiate some type of deal where they agree to release the lien against your house so that you can move forward. But that's just another headache that you have to deal with. Had you not added this person to the title to your home, you wouldn't be dealing with that. You'd be able to refinance, sell, do whatever you want to with your house. Let's talk about the third risk, and that is incorrect paperwork. So you watched my video from a few years ago admonishing you not to add anyone to title, but because you're so in love, you do it anyway. But you don't want to pay an attorney to prepare the documents for you. So you go online, you find a quitclaim deed, you fill it out, you sign it in the presence of a witness and a notary, and you have it recorded. But you didn't fill it out correctly. In Georgia, there are 2 primary types of tenancy. The first is tenancy in common. The second is joint tenancy. We have tenants in common, we have joint tenancy. So let's talk about tenancy in common. Tenancy in common. John Doe owns a home. He wants to add his girlfriend, Jane Smith, to title. He goes online, he prints the forms out, fills them out, records them. I, John Doe, am granting to John Doe and Jane Smith this property. He has created a situation where they hold title as tenants in common because that grantee clause where he names who he is conveying the property to, John Doe and Jane Smith, that's all it says. That means that they are tenants in common. So let's say that John Doe has a couple of grown kids and he has added Jane Smith to title. And his intention has always been for his kids to get the property when he passes away. Jane Smith actually predeceases him. She has an untimely death. What happens to her interest in that home? Well, because they are tenants in common, her interest doesn't automatically go to John Doe. It goes to her heirs, whether or not she has a will. If she has a will, and there's provision in the will that says that I hereby bequeath any interest in real estate that I have to my daughter, that means her daughter now has an interest in the property with John Doe. If she doesn't have a will, that means that the state will decide who gets the property. And what John Doe didn't know is that Jane Smith is not legally divorced from her first husband. Under Georgia's laws of intestacy, that husband, even though Jane was separated from him, would be the first in line to inherit her interest in that property. So now John Doe is going to own property with Jane Smith's first husband. Awkward. So that's the danger of doing it incorrectly, doing it yourself. Now, the second type of tenancy is joint tenancy. And when you hold title as joint tenants, we know that because the deed has particular language in it. So when John Doe was quitclaiming half of his interest in the property to Jane Smith, what he should have done was that I, John Doe, hereby convey grant, blah, 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 to John Doe and Jane Smith as joint tenants with full rights of survivorship. That's the magic language, joint tenants with full rights of survivorship. So what happens when Jane Smith dies? Her interest automatically reverts back to John Doe. And he's whole again. He owns the property by himself. He doesn't have to worry about Jane Smith's first husband, her daughter, or anybody else. If and when he decides to sell the property, all he has to do is execute an affidavit explaining when she died, where she lived at the time of her death, blah, 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 and attach a copy of the death certificate. And that puts the world on notice that Jane Smith passed away and that her interest in the property reverted back to John Doe. But when you're doing it by yourself and you don't know what you're doing, you are at risk of making that kind of mistake that could potentially be very costly and certainly very inconvenient if you end up owning property with somebody that you don't know, somebody that you may not like, etc., etc. If you've followed along with me up to this point, go ahead and drop the word deed into the comments just to let me know that you're still watching. Now, my general warning is to never add anyone to the title to your home. However, there are certain exceptions, and one of the biggest exceptions, at least in my opinion, is when you have an elderly person or someone who has some type of serious illness and they have a family member come in to be their caregiver. And maybe that family member sells their home to make this transition, and the elderly or sick person at some point during this whole caregiving journey decides that it would be best if they added their caregiver to the title to their home. They feel like that's the least they could do. This person has made a huge sacrifice, and it would just be so much simpler if the person's name was added to title. If you're going to do that, make sure the person is added as a joint tenant with full rights of survivorship, number one. Number two, one of the things that you could consider is to execute what's called a transfer on death deed. Now, in Georgia, prior to July 1st, 2024, transfer on death deeds were not recognized. But now that they are, it is a very good tool for a couple of reasons. Number one, it's a way to avoid the property having to go through probate, as is joint tenancy or a revocable living trust. Number two, it allows you to put in motion the transfer without finalizing the transfer. That means that if the person has liens and judgments against them. They won't attach to your property. And up until the day that you pass away, you can do whatever the heck it is you want to do with your property. The transfer is effectuated after you die. So how is that transfer effectuated? The person to whom you want to transfer the property upon your death would have to file an affidavit that sets forth the required language that you passed away, the date of your death, the county of your death, referencing the transfer on death deed. And let me backtrack for a second. The person, the homeowner, would have to execute the transfer on death deed and have it recorded. It's there in the county records, but it does not effectuate the transfer. You're not getting anything until the person has died and you, as the transferee, file the appropriate affidavit along with the death certificate of the homeowner. You have 9 months from the date of the person's death to file that affidavit along with the death certificate. And you file these documents in the real estate records of the Superior Court in the county where the property is located. If you don't file the affidavit and the death certificate within 9 months, the transfer on death deed becomes void and you would have to go through the probate process to get the property. If the person has a will and they left the property to you, great. If the person doesn't have a will, then the estate would have to be administered and the laws of intestacy would come into play. Intestacy would come into play. So you might not be the person who is first in line to get the property. Maybe you're a niece and the deceased homeowner had a daughter or a grandchild. You wouldn't be at the top of the list to get the property, and that could result in some family squabbles or what have you. But again, a transfer on death deed is an option to protect your interest in the property while at the same time looking out for the person that you want to get the property when you pass away. So those are just a few of the risks to adding someone to title. If you found this video informative, like it, subscribe to my channel, and I will be back real soon with another video.